Hello, everybody, and welcome to our Health Law Expressions podcast on political campaign intervention by nonprofit tax-exempt organizations. I'm Dan Mulholland, and with me is my partner, Henry Casale. Many of you probably know Henry from the very popular audio podcast, The Kickback Chronicles. So Henry's decided to go big time now and be on the video with me, and we're reminding people that we do have faces made for radio, but hopefully that won't distract you from the important message we're giving today.
Thank you very much, Dan. Thank you for this opportunity to be seen.
So it's always good to be seen and not seen. The reason we're talking about this should be obvious. This is an election year, and we're in Pittsburgh, Pennsylvania, a so-called swing state, where about every 2 seconds on the TV, radio, and the internet, we're bombarded with political commercials from various candidates and different parties. That's all well and good. But if you're a nonprofit tax-exempt organization, like most hospitals and health systems are in the country, there are some very strict regulations from the Internal Revenue Service about your ability to intervene in political campaigns and your ability to engage in propaganda or lobbying activities. Now, we'll talk about that in a little bit, but the prohibition against nonprofit tax-exempt organizations being involved in political campaigns has been in the tax code in section 501c3 for decades. And it's an absolute prohibition. It just says that a nonprofit tax-exempt organization under 501c3 is prohibited from participating in or intervening in, including the publishing or distributing of statements in any political campaign on behalf of or in opposition to any candidate for public office. That any means that the prohibition is absolute, that even a de minimis amount of activity that would be considered intervening in a political campaign could jeopardize your tax exemption, and penalties range from revocation of exemption to possibly an IRS injunction action, a warning, or being sent to bed with hot supper. But it's pretty serious stuff. And because the possibility of a penalty is enhanced, because if you get involved in one campaign, the other campaign isn't going to like it and more than likely to file a complaint. You have to be cognizant of these rules. And the IRS, about every 4 years, reminds people of this prohibition. But it's important to understand that if you lose your tax exemption, it's not just an issue that we have to pay taxes going forward. You could be liable for back taxes, penalties, and interest from the time that the IRS found that you violated this prohibition against political campaigns. And second, you could lose tax exemption on your bonds, which could cause bondholders to bring action against you. And it might affect your state and local tax exemption as well. So you need to take this seriously. Now, having said that, when you look at the IRS guidance, it's clear that there are some things you can do that don't cross the line. And Henry, maybe you can summarize some of this guidance the IRS has given both recently and over the years.
I'd be happy to, Dan. And while the presidential election seems to take up all the oxygen in the room, remember, this applies to any election for any public office, so that state, local, whatever election may be going on in your area, these rules apply. Now, the
IRS, whatever. I mean, it doesn't matter. Yeah.
So the IRS recognizes that because this is a complete ban and prohibition, that they wanted to provide some guidance on what you can and can't do. So they began in 2007 by issuing a revenue ruling referred to as Revenue Ruling 2007-41, which provides 21 examples of do's and don'ts and what you can do, what you can't do, and various examples that they provided. They then followed up that advice in April 12th of 2024 with Congressional Research Service Guide. In August of 2024, they issued frequently asked questions, referred to as FAQs, about the ban on political intervention. And they also have a mini course on the ban on political intervention. So they recognize that they mean what they say, but they want to provide guidance on what does it mean to be prohibited from intervening in a political campaign. And what they have stated is that a hospital engages in political campaign intervention when it makes or solicits contributions to or for candidates or political organizations, endorses a candidate or rates the candidates, no matter how objective the rating may be, publishes or distributes partisan campaign literature or written statements, has its representatives speak out about a candidate, and or uses its resources to influence an election. Now, but even within that description, it's essentially a facts and circumstances test as to whether or not you're violating the IRS's prohibition. And so what we wanted to do was to give you some of the examples that the IRS has provided in their various publications. For example, Dan, let's start with something relatively straightforward like voter education. What can you do?
Yeah, voter education is something, if done right, you're allowed to do. And I'd also urge you to look at those guidances that Henry mentioned. You get on the IRS website, irs.gov, click charities and nonprofits, and then look for political campaign intervention. You'll get it all there. But if you're engaging in nonpartisan voter registration, you just have a voter registration table set up in your lobby, your parking lot, whatever, and it's nonpartisan. You're not encouraging people to register in one party or another. Or voter education, such as by hosting a forum or hosting a debate where all the candidates have an opportunity to participate. Generally, that's okay, but there are some limits, right?
Yeah,
Henry?
you can't conduct a voter registration or education that shows a bias, a preference in content, or prohibits the views of a particular candidate. Also, Dan, you can invite a candidate to a hospital event under certain circumstances, correct?
Yeah, I mean, it's pretty common that one of the candidates will already be an elected official, congressman, senator, state representative, and that from time to time, a hospital or health system might want to have that individual come to the hospital to, see their operations or to speak to the staff, whatever. Generally speaking, it's okay to have somebody, whether they're elected or not, who might be running for office, come and talk to people at the hospital, but they can't do so for the purpose of either fundraising or referring to the fact that they're a candidate for office. So if, Willie Ward Healer came into the hospital and he was your local state senator, Willie could come shake hands, say about the nice things that the state's doing for the hospital, but he wouldn't be able to mention the fact that, and by the way, vote for me because I'm running for re-election against some bum. So there are some limits about that, but you can certainly host someone who might be running for office, whether they're elected or not.
Whether it's opening a new wing or other event at the hospital, you can even introduce the public official. You just have to be careful about not being seen as endorsing that individual in their run for public office.
Yeah, so another thing that you can do, the IRS is okay, is invite a candidate to speak at a hospital event in their capacity as a candidate, as long as you invite the other candidates who might be running for that office. You have to be completely agnostic and nonpartisan about that, but that's okay if you give everybody an equal chance. So example would be a candidate forum. The hospital or the health system might be sponsoring something, or perhaps they're not sponsoring it, but their facilities are being used for a candidate forum. As long as all the candidates appear on the same stage and answer questions covering a broad range of issues that are posed by an independent, nonpartisan moderator or panel, that would be okay according to the IRS. But everybody who's on that panel, all the candidates have to give an equal opportunity to speak. And the organization, the charitable organization, the hospital or health system, has to make it clear that they neither support nor oppose any of the candidates who are appearing at the forum. So it has to be completely nonpartisan, and no fundraising is allowed at all.
And if you've ever watched any of the presidential debates, you'll appreciate how difficult this can be, even if you start out wanting to give everybody the same same amount of time and try to make it as nonpartisan as possible. So you have to be careful about allegations that you're limiting the number of candidates, or you're limiting a candidate's ability to speak, or you participate in one candidate's re-election meeting, rally, etc., or show bias in any way in the questions, or by commenting on the questions, the answers the candidates present in their presentation. So again, while you can do this, you want to be very careful because it's really difficult because of the nature that debates are taking on today to not run afoul of the rules in this area. So you can permit a candidate to an event you can also permit a candidate to attend an event that's open to the public, but you don't want to publicly recognize the candidate or invite the candidate to speak at the event in their capacity as a candidate.
So, Henry, you raised a good point. The way political campaigns tend to be nasty nowadays, you might want to check your liability insurance policy in case some people get in a duke-a-roo, either the candidates themselves or their supporters in the audience. And that's only half facetious, because sometimes if you have a large number of people who are coming to an event, then there's always the potential that something could go wrong, or maybe it has nothing to do with the candidates, nothing to do with somebody threatening violence against anyone or trying to carry it out. It could be just somebody wrecks their car into somebody else's car, and you're going to be responsible. That brings us to the next issue, which is, can you allow your facilities to be used by a political campaign? And a lot of times this has to do with auditorium or maybe parking lots, or you might have a large piece of property, say a park that the hospital owns or manages. You can lease it to a candidate to use for a political purpose, as long as you're going to make it available to all other candidates on an equal basis. And it's probably a good idea to charge some fair market rent. If, for instance, there's a campaign activity down the street, and the campaign says, we have a whole lot of people coming here, can we use your parking lots for this? Say, yeah, you can. You have to pay for them. Set a fair market rate, not exorbitant, but something that would be reasonable to cover what your costs are. And then you can do that as long as you tell the other candidates, you want to do it, you want to have a forum here, you can park. Again, check your insurance policies, and you probably don't have coverage for outside events, in which case you may want to talk to the campaign. Let us see your liability insurance. Let us see a certificate of insurance that you have coverage in case something bad happens here, and we want to be named as an additional insured. We actually have had experience with this recently, and the campaigns will always comply. They have insurance, and you want to maybe check out the insurance company to see how it's rated. You know, if it's Joe's insurance company and you don't know who Joe is, you might want to ask for more information.
But Dan's recommendation about establishing the fair market value of the rent is very, very important, because one of the things you can't do is you can't favor one candidate over the other, and that could be evidenced by offering a rate that's lower or preferential to one candidate over the other. So I think that the more you can establish objective fair market value rates at the outset, the less opportunity there is to run afoul of the IRS on this particular issue.
So that's so far what we've been talking about is the organization, the tax-exempt organization. What about the people who work for that organization, or the people on the governing body, or just rank-and-file employees? All those individuals have a constitutional right under the First Amendment to speak openly about what their preferences are. But you have to be very careful that if somebody is doing so and it appears to, or they represent that they're doing this in their capacity as someone who represents a nonprofit tax-exempt organization, that can get into trouble. So, for instance, a leader of a nonprofit organization should not make partisan comments in any official organizational publications or any official functions. That goes from the CEO on down. But one example, Henry, I think they gave is, what if the CEO does something? What can the CEO do or not do?
Right. The CEO of a hospital doesn't lose their First Amendment right to endorse a candidate just because they're the CEO of the hospital. However, they have to he or she has to recognize that the CEO could be seen as the representative of the hospital, so they have to take actions to make it clear that this is their individual views, and so that the CEO is to pay for, and if he or she wants to endorse a candidate, it needs to be clear that or if a candidate wants to add the CEO to a list of individuals who have endorsed that individual, it needs to be made clear that that there's a disclaimer that these are the views of the individual and not the organization. Because as long as the ad is not paid for by the hospital and the endorsement is made by the CEO in his or her personal capacity, it's covered by the First Amendment, and that would not run afoul of the IRS's prohibition.
Yeah, another example might be a hospital board chair. Let's say that board chair is the president of the local bank, and that individual attends a press conference at the candidate's campaign headquarters and personally endorses the candidate. But he doesn't say that he's speaking on behalf of the hospital. At that point, if the endorsement is published in the local newspaper saying that Joe Blow, the hospital board chair, has endorsed Willie Wardheeler, under those circumstances, it's okay as far as the IRS is concerned because the hospital and the board chair didn't say they were doing this in the capacity of the individual's role as a board chair, but simply did this as an individual. The fact that the paper picks it up and says, Joe Blow's the board chair does not constitute interference with an election or involvement in a political campaign. But it's always very important for anybody who has a high profile in the community, whether they're on a hospital board or not, to make it clear if they're endorsing it as an individual and not on behalf of their organization, because that could have ramifications beyond just the 501c3 issues.
And you want to be careful about hospital publications, whether it's a newsletter or even a website, that if the hospital CEO, if it's a hospital or other tax-exempt organization website, if even if the CEO has a column saying that it's called My Views, and in those views the CEO endorses a candidate, even if the CEO were to contribute to the cost of the newsletter or the other publication, since it's an official publication of the hospital, it constitutes campaign intervention by the hospital. And the same thing would happen if the CEO makes partisan comments on at an official hospital function. So if the hospital is sponsoring the event or the publication, you have to recognize that the IRS will view that as a publication of the hospital, and therefore these rules will apply.
So now we're going to move slightly beyond the issue of intervening in a political campaign to the hospital's ability to take positions on public policies and to engage in lobbying in one sort or another. It's perfectly okay for hospitals, health systems, any tax-exempt organization to take a position on a public policy issue. For instance, you could say we need more funding for Medicare. We need better funding for rural health care, whatever. Even though some of those issues might have different views by different candidates. But you have to make sure that that's all you're doing is saying, we believe it would be better to have better Medicare funding, and not start going into the point of saying, and because Willie Wardheeler is in favor of that, we like him.
Yeah, so you can't benefit one candidate directly or indirectly. You can't show a picture. You can't refer to the candidate's position on that particular individual. You can't even refer to their political affiliation, because some parties are more affiliated with certain positions than others, or provide distinctive features of a candidate's platform or biography. So this is a very, very complicated area. And because, again, the facts and circumstances nature of the test that the IRS uses, we would urge you to make sure you run this past your legal counsel before you make any kind of statement on a issue of public policy. We want to quickly address contributions to 527 organizations such as a candidate committee, political action committee, or a PAC. And essentially, a tax-exempt organization is prohibited from directly contributed to any kind of 527 political organization or maintaining a separate segregated fund under Section 527 of the tax code.
Yeah, now that applies to 501c3 organizations. Technically, a 501c4 organization might be able to do that, but we're not going to get into that level of detail. Just, again, as Henry said, don't be trying anything in this area without close adult legal supervision. Now, it's okay if you have, let's say, the local hospital or state hospital association has a PAC, and they said, would like to have contributions. The individual, maybe the CEO of the hospital or their government relations person, could always individually talk to board members and said, hey, you might want to consider giving some money to the hospital association's PAC because they're going to bat for us on some of these important issues. That should be entirely up to the individual involved, number one. Number two, do not do that at a meeting. If, the State Hospital Association PAC says, hey, we need some help, tell your folks about this, do it after the meeting or just by, a quick phone call, but don't be actively soliciting as a representative of the hospital or at any kind of official hospital meeting or function for donations to a PAC, even if it's a friendly PAC like one from the hospital association.
Now, we've been talking a lot about what the IRS says you can't do, and we want to end by talking about what you can do. And the IRS tax code does specifically permit a 501c3 organization to engage in lobbying, which is the action of influencing legislation. It is not the same as intervening in a political campaign, and it is permitted to a certain extent. Right, Dan?
Yeah, it's permitted, but again, you have to be very careful because there's very technical rules on this. First of all, the amount of lobbying expenditures that are permitted depends on the size of the organization. There's a maximum amount of money that can be devoted to lobbying by any tax-exempt organization of up to $1 million a year. So you go over that limit, you could have a problem. You also have to make a formal election to do that under Section 501E of the tax code. And your bylaws and articles of incorporation ought to refer to that you're, at least corporately authorized to make that election if you so desire. And if you engage in excessive lobbying over a 4-year period, that can jeopardize your tax-exempt status. And if you exceed lobbying expenses in a particular year, you can get hit with an excise tax up to 25% of the excess amount that you spend. If you're a small organization, you probably ought to just stay away from any kind of lobbying. Larger organizations with the infrastructure to deal with government relations issues probably have a better ability to track this, but even there you have to be careful.
So we want to end by saying that tax-exempt organizations can get dragged into various kinds of political intervention, willingly or unwillingly. You want to be very careful because this is an area that the IRS takes very seriously. And again, no amount of political intervention is permitted, but we hope the facts and circumstances test that we've described during this podcast will allow you will provide some guidance to give you an idea of what's permitted, what you can do, and what you need to stay away from.
So yes, we'd like to thank everybody and remind you, please do vote. Vote early if you want to, but don't vote often. That can get you in trouble. Thank you very much.